5 seconds to go. Start. Learned counsel appearing on behalf of the state while opposing the present appeal has vehemently submitted that in the present case the dead body was exhumed from the place shown and identified by A1. It is submitted that the place of burial shown by A1 and the identification of the body by him has been duly proved by the prosecution. The evidence of anthropology of expert is accepted. It is submitted that even the stolen car was also recovered on the basis of disclosure statement made by A1. It is submitted that engine and gearbox were found to be in custody of PW17 on the basis of disclosure statement made by A1. It is submitted that PW17 has deposed that some parts were sold by A1. It is submitted that aforesaid crucial circumstances have not at all been explained by the accused in his further statement under section 313 CRPC. It is submitted that deposition of DW1 has been rejected by the courts. It is submitted that therefore no error has been committed by the courts below in convicting the accused for the offence punishable under section 302 and other offence of IPC. Making the above submissions, it is prayed to dismiss the present appeal. We have heard learned counsel appearing on behalf of accused as well as the state. We have gone through the findings recorded by the learned trial court as well as the High Court while holding the appellant accused number 1 guilty for the offence punishable under sections 302 and 201 of IPC. It is the case on behalf of the appellant accused number 1 that he has been convicted on the confessional statement and therefore in case of circumstantial evidence and unless and until the complete chain of events were proved and established, he could not have been convicted on confessional statement. However, from the judgment and order passed by the learned trial court as well as the High Court, it cannot be said that the appellant has been convicted on the basis of confessional statement. In the present case, there is no confession by the accused that he committed the offence which has been but relied upon by the court. The so-called communication by the accused is, as such, not believed by the High Court. However, at the same time, it can be seen that the communication or letter received by police on 30th December 2007 was the cause for reopening of the case, as earlier the case was closed on 4th February 2007 as untraceable, that thereafter the actual investigation began by PW30, that thereafter during investigation A1 disclosed the place where he had buried the dead body of the deceased. The dead body was exhumed from the place identified by A1. Thus, it was a case of recovery of the dead body at the instance of the accused from the place which was disclosed by the accused, who can be said to be in exclusive knowledge of the place where the dead body was buried, that thereafter the superimposition test was conducted and the DNA examination was conducted on the bones and the skull, and it was proved that the dead body was that of the deceased. This is the first strong circumstance against the appellant A1 which has led to his conviction, that thereafter even the car which was driven by the deceased at the relevant time was recovered from PW16, which was at the instance of the accused himself, that there is a recovery of car driven by the deceased from the place and the person disclosed by the accused number 1 appellant. The prosecution has successfully proved the same by examining PW16, a person to whom the stolen car was sold by the appellant accused number 1. This is the second strong circumstance against the appellant accused number 1, that thereafter the prosecution has been successful in proving that the engine and gearbox which were sold by the appellant accused number 1 was recovered from PW17. The engine and gearbox of the stolen car were found from the custody of PW17 on the disclosure statement made by A1. Though PW17 has turned hostile, however, at the same time, the recovery of engine and gearbox from PW17, which were recovered on the disclosure statement made by A1, has been established and proved by the prosecution by examining police witness PW30. We see no reason to disbelieve PW30 on the aforesaid. This is another circumstance against the appellant accused number 1. Thus, on the basis of the aforesaid strong circumstances, when the learned trial court as well as the High Court has convicted the accused with the same in exercise of powers under Article 136 of the Constitution of India. Stop.